Welcome. My name is Leo Flor, and I'm a staff attorney at Northwest Justice Project in Seattle, where I work on our Veterans Project. My practice focuses primarily on representing low-income veterans who are what we call criminal justice involved, so veterans who are either defendants in criminal courts, primarily therapeutic criminal courts, veterans treatment courts, which we have 3 of in King County, and there was one for a while in Tacoma, although it's sort of reduced in its current form. And then also incarcerated veterans, so veterans who are incarcerated either in state prison, primarily at Stafford Creek Correction Center in Aberdeen, and increasingly also in the county and city jail system up in King County. So we're going to talk discharge upgrades and then exercising a little initiative I threw in VA character of service determinations, just because these two issues are usually inseparable, at least in the provision of legal advice for people who are in this type of situation. The slides up here are sort of cut off on the bottom. One thing just to draw attention to, I'm not here to have you in 45 minutes proficient in the production of a discharge upgrade brief or character of service determination argument. So what I really regard my goal as is to connect you to some resources that you can use after the fact that really are, I think, what is necessary to start producing these briefs, these legal arguments. And then also to sort of lay a framework that makes these particular legal actions just make a little bit more sense, I think, in the context of how our clients actually experience them. And then we've got this website, which is one of those resources that you can check out. So in the Army, bottom line up front is the big deal. I don't waste my time with the details if you can just tell me what's important. And so the really important part of what we're trying to do here, the sort of nutshell of this, is that discharge upgrades is a blanket term that's not legally precise in any useful way. And so we're really talking about 2 different types of action that can be used when a former service member has discharge information that is preventing them from achieving their goal. And a discharge upgrade is a way to actually change that information as a legal matter, and a character of service determination is a way to have that information mitigated in order to establish eligibility. And there are 2 different authorities that are involved here that it's also important to just sort of hang on to very quickly. So a discharge upgrade is with respect to the former armed service of the veteran, to the Department of Defense. Whereas a VA character of service determination, I always say that way because it applies to the VA. One can be binding on the other while the other isn't binding on the one, and we'll talk about that at the end, and you can just let that suspense cause you to pay attention as we go forward. Before we get into the framework, just 2 prerequisite concepts that I want to go over very quickly that some folks are very familiar with and some folks are not. The characterization of service, which is commonly referred to as the discharges, we'll get into in excruciating detail in about 5 minutes. There are 6 of them for our purposes. They fall into 2 classes, administrative or punitive, where administrative characterizations of service tend to have been given with less process, we would say in a sort of criminal context, and the punitive ones come with more process. And the names are sort of listed up there. And the overall theme for this entire presentation is that the word honorable was very poorly chosen by the people who designed this entire system. You're going to get a lot of derivations of honorable, other than honorable, under other than honorable, honorable for VA purposes. That's all going to come up. And so I'd really like to highlight this in the beginning just to say these are the 6 characterizations of service. They don't necessarily correspond to some other instances of the word honorable that we'll see, and just to highlight the confusion ahead of time. The second thing, have no specialized expertise in, but just because it comes up in the presentation and it's more convenient to talk about it here, is that when we talk about courts martial, there are 3 different types. There is the sort of summary court martial, which often ends up happening at a battalion headquarters in the Army where people are just sitting down and it's just one officer overseeing and they don't really necessarily even have to have that much legal training. And then it goes all the way up to the general court martial, which is, looks very much like, and often people will say more like, or more protective than a sort of normal federal civilian criminal process. And then we've got in between there this issue of the special court martial. And again, I bring those up only because they affect what we're about to dive into here in the framework. So agenda-wise, I want to just talk about 3 main things today. The first is this question of who is a veteran, or what is a veteran, or what makes a person a veteran. I've never quite figured out the best way to phrase that question. And then talk about these 2 specific types of action, the discharge upgrade at a superficial level, and then the character of service determination at a slightly more superficial level. So who is a veteran? Just at the outset, I think it's useful to kind of contrast or at least identify this dissonance that we have between what we would consider social definitions of veteran, so those people that we see walking through the airport and we buy them free Chili's meals, versus people that a particular government agency usually defines as eligible for a particular type or set of benefits. So we have these social definitions of veteran, statutory definitions of veteran, where statutory really means statutory and regulatory. And the point is that those things don't overlap perfectly. That very often somebody who we would consider to be a social veteran, me in Afghanistan or this gentleman on the corner, ends up not being a veteran for statutory purposes with respect to the VA primarily. After a brief sort of listen to the audience, a lot of folks are familiar with the armed forces generally, but just to say it, we've got this framework where a veteran for statutory purpose is a result of these two parts of an equation where we have qualifying active service and non-disqualifying discharge. Depending on whether your service was exclusively or partially in the active duty, reserve, or guard, those interact in interesting ways to determine whether your particular service was qualifying. And then we talk about the non-disqualifying discharge. And this is what I really want to spend time on because that's what's relevant for our subject matter here. So a discharge, which again is a sort of not usefully precise term, as a legal matter is really built up of these two subcomponents. So we've got our characterization of service, and we talked about how there are 6 of them. There are older names for them, like undesirable, for example, is now the OTH. And then there's the reason for separation. And these two things show up on a DD-214. And if you don't know what a DD-214 is, we'll have a little example of one in a minute. But this is what I'm talking about when I talk about the discharge, as we would normally talk about it in a discharge upgrade context. There are reasons for separation that trigger statutory bars and regulatory bars for VA purposes that we're going to talk about later, but I just put the asterisks in there now, which I realize is probably not entirely visible at the bottom of this screen, but should be on your slides. And so just mentally asterisk that because we're going to talk about it in the context of one of these two types of actions later. So the thing I like to always point out is that we misuse these things commonly. And the point is not that we could all go around and begin to correct people and make ourselves feel good and make them feel stupid. It's just that as a legal advocate, particularly, we have to be able to ask our intake questions in a way that elicit the information in a useful way, and this framework will do that. So medical discharge is the sort of classic because it can be a mechanism of discharge. People often use medical as if it were the characterization of service, forgetting that there's an attendant characterization of service. And so that's usually the most complicated one. But if you wanted to be that jerk who walked around and made people feel bad and tried to make yourself feel good, you could say, no, you don't have a medical discharge. You have a medical reason for separation, and then some characterization of service that you're not talking about right now, probably honorable, but not necessarily. So DD-214 wise, on a member copy 4, and not all copies are member copy 4, there's a block at the bottom. And that block at the bottom contains this information. And these are 2 examples of the characterization of service and the reason for separation, and sometimes called the narrative reason for separation being listed. I say member copy 4 because all members are also given a deleted copy of their DD-214 that does not contain this block at the bottom. So when you ask for the DD-214, you want member copy 4 and not just the DD-214. As a statutory matter, federal, state, and local definitions of veteran don't necessarily correspond, such that one could be a state veteran for some purposes, not a federal veteran for VA purposes, or a federal VA veteran for the purpose of one benefit, but not for another benefit. Just to demonstrate how this actually works, let's talk about the baseline federal definition of veteran for a statutory matter. And that's what's depicted on the screen. And we can apply our framework and identify the 2 pieces at work within that definition. And then get to this phrase that is really sort of central to everything that we're going to spend the rest of the time talking about, which is under conditions other than dishonorable, which is the first and worst instance of the word honorable causing tremendous confusion for people who work with this stuff all the time. So the question here is, using our framework, what combinations for VA purposes cause somebody to be considered under conditions other than dishonorable or separated under conditions other than dishonorable? What combinations of their characterization of service or the reason for separation do trigger that, or perhaps trigger that and then redeem that. And that's really the sort of space, the terrain that we're going to be in. And again, what really influences that is these federal statutory and regulatory bars that we can talk about towards the end. I've included in your slides that we're not going to talk about here, but we do in other presentations, how this looks with some of our state statutory definitions of veteran. And there are definitions of veteran, of course, but that's not really something we're going to spend time on today. Other than to note that a discharge upgrade is going to affect eligibility for these state definitions or even local definitions the same way it would for federal definitions of veteran. It's more complicated than it seems when you're walking through the airport. Now, this is a little bit hard to see, but this to me is the real so what. Red, so this is classic, command and staff Army slide style, but red is not eligible, yellow is eligibility possible, green is eligible. We've got the characterizations of service. In one case, sort of disaggregated between issued in a special court martial and in general court martial, and then across the top, we have a couple sources for statutory definition of veteran. And the point here is that, as you can see, depending on what the source of the definition is and the characterization of service, one person can be a veteran for federal purposes, but not at all for state purposes. And discharge upgrades is the process of turning as much of this green as possible for a particular veteran. Let's get into these two actual causes or mechanisms that we can use once we sort of understand the framework. And again, the discharge upgrade has nothing to do with the VA. It requires no VA accreditation. It doesn't require that you be an attorney, at least in its initial stages. And there's actually not a credential required to practice at all before these boards the same way there is for the VA. So you can just be a friend and help somebody with the discharge upgrade. Although what we know, at least sort of anecdotally, is that rates of success, which tend to be relatively low for discharge upgrades, increase with the assistance of an advocate who's trained. DRB, BCMR, BCNR. These are the things that you hear about in discharge upgrades. And this is the once over the world here. A discharge upgrade can be issued by one of two Army or Air Force or Marines and Navy together, administrative boards. There's the Discharge Review Board depicted on the left of the screen as you're looking at it, which should be thought of as the board of first instance, or the place you should go to first or must go to first if you can. And then to the right, the reason these are sort of depicted side by side is that the gentleman had a question of what is this 15 years SOL or statute of limitations non-waivable? These boards have statutes of limitations, and it's important to understand what they are because in one case it's longer but not waivable under any circumstances, and in one case it is much shorter but waivable actually under most good faith circumstances. So the Discharge Review Board, where you have to bring your claim first if you can bring it there, you can only bring that claim if it's within 15 years of the date of separation. And it's not waivable under any circumstances. And there are decisions that interpret that from federal courts that confirm that it's not waivable. It's very clear in the statute. So in order to bring a case to the Discharge Review Board, in order to seek relief, which is more limited in terms of what the Discharge Review Board can actually grant, you must do it within 15 years from the date of separation. And that's the application made within 15 years. That's not the application decided within 15 years. So if the 15 years lapse after submission of the application will still be considered. And then just to jump over, and what we can kind of do is ping pong between these two boards, comparing some of their salient factors here. The Board for Correction of Military Records or Board for Correction of Naval Records, which is the BCMR or BCNR that you hear, and again, the Naval Records one incorporates the Marines, has a 3-year statute of limitations that is waivable on a standard called in the interest of justice, which basically means they will look into any application made and consider its merits in order to inform that determination of whether or not it is in the interests of justice. So, and it's 3 years from the date that the injustice has been discovered. So you could be 70, have left the military at 22, thought everything was just the way it was supposed to be until you turned 70, And then at 70 said, I have discovered an injustice in the way that I was separated from the military. I can no longer bring this to the discharge review board because 15 years are past. I would like a waiver of the statute of limitations in the interest of justice because I am bringing it within 3 years of having found it. And it's a little complicated as to whether that'd be interpreted as a waiver or just within the statute of limitations. But the point is the BCMR and BCNR are very lenient and generous in taking a look at those to at least see if this case has anything to it. They very rarely just reject out of hand one of these applications as not having been brought within the statute of limitations if you make any sort of superficial argument as to that issue. The other real thing to understand that distinguishes these two types of board, and again, all the services have both of these types of board to include the Coast Guard, where the Marines in that context aren't considered a service, which I usually like to say out loud just to piss off Marines. It's important to know what they can and can't do. The discharge review boards are very narrowly empowered by their statute. They can change characterizations of service that are not dishonorable characterizations of service, and that's really just an interpretation of the fact that they can't overturn anything that a general court-martial did. And then they cannot change RE codes. And then in the case of a bad conduct discharge issued by a special court-martial, they can only consider it on the basis of clemency as opposed to the other two standards that they would normally be able to consider it under, which are propriety and equity, if I don't have those two reversed. I don't. And so what I just talked about is the three types of argument that you can bring to a discharge review board. Propriety, you guys did this wrong. Equity, this is unfair. Or clemency, yeah, but look at what I've done since then. And those are the three species of argument that you're allowed to bring. And what you'll find if you bounce back over to the right on the Board for Correction of Military and Naval Records is that they have analogous categories that are less well defined in their implementing statutes, but which we consider to be about the same thing. So you did this wrong, this isn't fair, or clemency, where you can now apply this to any characterization of service regardless of the mechanism with which it was given, including conviction in general court-martial. Please. To repeat the question, is this a derivative finding by the board based on a previous finding by some other body as to there having been clemency? And the answer is no. It's a first instance look. We decide that it was proper and it was fair, but based on what you've been doing now, we essentially want to forgive you because the results of these types of characterizations of service can be so damning for so long in people's lives. So again, to jump back to these boards for corrections of military records, anything goes in terms of the type of discharge, where discharge equals characterization of service and narrative reason for separation that you have, and everything else. So, and this is something that gets lost in the discharge upgrade conversation very often. Re-enlistment codes are fair game. Whether you should have been medically retired instead of separated based on on behavior at all is fair game. You can really just go back and say, I was separated from the military incorrectly, and it's just that medical separations tend to be where that happens. And I would like the board to reconsider that. So it's very often the case that the BCMR or BCNR says, yes, not only was your separation or your separation inequitable or unfair or wrong, but you also should have been medically retired despite the fact that your service was less than 20 years. And then you can get back pay that attends to that. So it can be a pretty significant source of relief for folks who have been out for some time or very little time. So any question on these big two categories of things that can provide relief in this type of action called the discharge upgrade? You'll also see it as discharge upgrades and records corrections in some cases. The Board for Correction of Military Records is also where you would go if you should have had a star award on your, Global Expeditionary Terror or War on Terror Medal or something like that. We talked about the decisional standards that these two boards exercise. This, it's not fair, it was done wrong, or please forgive me. There is a presumption that operates on both of these boards that has been very clearly upheld by reviewing courts, called the presumption of regularity in government affairs. And this combined with requesting records is what makes discharge upgrades hard. Because it is not enough to allege based on lack of records that something didn't happen correctly. These boards presume that it happened correctly, and you must provide affirmative evidence that it did not happen correctly. So, as is often the case in my cases, if you're working with someone who was separated from the military 30 years ago, sir, the question is, what is the composition of these boards? And it's important to know because it, in some cases, can really affect the way that you choose to make your argument. So a discharge review board from all of the services is going to be composed of members, officers from that service, usually of the rank of 05 or 06, who work in a pool and they essentially get called in on these 3 or 5 member teams that consider the applications. So it's currently serving members of that force. So you can, to some extent, begin to see how that may or may not color the way that they entertain particular types of argument. DRBs also, in some cases, will bring in experts from other fields depending on the type of action that you're requesting for. So if it's a PTSD-based application, for example, it might be appropriate to bring in a physician. Boards for correction of military records, in contrast to discharge review boards, are composed of teams of 3 civilians. Now, they're civilians that are employed by the service, but they don't necessarily have to have had a military career at all. So discharge review boards is usually lieutenant colonels or whatever the sort of seafaring equivalent of that is. And then these boards for correction of military records are, what we consider high-ranking civilians who sit in review of those petitions. So often, in my cases, I get the client's account of what happened and it seems perfectly plausible and it fits the fact pattern that we'd expect to find, but getting records to support that can be impossible. So the question really then becomes what types of records could you get to allege that in fact the government affair was irregular, and it often ends up being a statement of somebody or statements of somebody, which wouldn't necessarily fly in a federal court in the evidentiary way, but often are considered in these types of proceedings. And I'll get into the types of supporting documents in another slide, but it's a very good point. And it's the sort of ray of hope that comes out of this otherwise really difficult presumption that we have to operate under. The VA has a statement in support of claim. The armed services have statement forms, and it's entirely you can use those. There's no problem with that, and in fact they help with making sure that something is properly signed and properly attested to, and that the correct information is given. I just got one in the mail today from prison. It's just a notebook, and they just sign their name in cursive at the bottom. So I'm going to have to go back on that one and get that statement. So you can't go that crazy, but there is not a specific form that's necessary. Another sort of potpourri thing just to bring up before we continue moving into the discharge upgrade process, just because this is a real, increasingly common and compelling basis on which to bring these types of action. And this is a discharge upgrade before either the BCMR or the DRB, where the argument is that the veteran had a post-traumatic stress disorder diagnosis that was not identified or properly treated, that contributed materially to the offense for which, or offenses for which, the veteran was ultimately separated from the military under some conditions that were, to use the bad phrase, other than honorable or not dishonorable. In recognition of this very large body of cases that we're really beginning to identify now, that these folks had PTSD, or what we would now recognize as PTSD, but they just didn't get the treatment that they should have, the military bears some responsibility for identifying that where the offense that caused the separation was at least arguably related to it, so that these folks can now become eligible for the treatment. Because if you'll remember, if you have an OTH, there's a yellow next to your name on the VA's the eligible characterizations of service. And it's possible that you could have served 20 years in the military, develop PTSD on multiple deployments, be separated for what is objectively a very objectionable type of activity, and then not have entitlement to VA services to get free mental health care for that. And it's just this recognition that that's not serving anybody, and it's certainly not fair. Sir, the question is there's been a lot of media recently about particularly what happened at Fort Carson, where mental health providers within the armed forces were not providing what we would consider adequate mental health care, and they were sort of dismissing what we would see as PTSD. And the question is, does this policy result from that specific incident, as I understand it at least? And the answer is no. It predates it, but it does come from the same general recognition. And the memo is actually, when you read through the whole thing, is written in terms of Vietnam-era veterans, but it's not limited to Vietnam-era veterans. It's this recognition that we used to call this battle fatigue, or we used to call this being a wimp, or maybe somebody just decided that they were going to deal with this because they were afraid of the treatment that they were going to get from their unit, which are all very real pressures. You don't have to hang out long in an infantry barracks to hear somebody being called a wimp or some version of that that's less palatable for a larger audience. So this memo does a lot of things in the context of PTSD, but it also shouldn't be mistaken for a panacea for all sort of effects of military service. It's very tightly focused on post-traumatic stress disorder, or what we would now recognize as post-traumatic stress disorder. But I highlight this because it triggers a relaxed consideration of those applications. And in fact, Yale and the Connecticut Veterans Legal Center just published a paper where, at least at the Army, applications that are submitted under authority of this memorandum as at least one of their statements of material contention have something like a 45% rate of success at the board, which far exceeds the sort of expected rate of success. So it's a powerful tool to have, and it also works for what is one of the most compelling fact patterns that we see in discharge upgrade applications, which is honorable service, not to use the military's definition of honorable, event, diagnosis, change in behavior, separation, where what happened after the event begins to recharacterize that entire period of service. And that's what they're trying to, I think, correct with this memo. And it seems to have been acted upon so far and interpreted the way that, at least as advocates, we would have hoped that it would have been. It can be a complicated process. It is superficially a simple process. And this is where my treatment of it is going to become more superficial, just because I want to highlight key things, but I'm not going to pretend that you're going to be able to come out of here and use this as a checklist to be complete. 4 general steps to one of these applications, and the first one is by far the most important, other than the fact that it's not sufficient. Getting the records and the evidence. I've included a link on your pages, it's there, and it's to a site that we put together, repoivets.org, where we have, as exhaustively as we can, listed all the places that you go to get various types of records. Often, people say, okay, military records, there's this form, the SF-180, and all you gotta do is fill it out, and then I get my DD-214, and I've got my military records. And that's the case for some VA benefits if you have a simple case. You're honorable, and you had sufficiently long service, and there's nothing complicated about it. But it is not enough for a case like this, where you're having to produce evidence to overcome a presumption of regularity in military affairs that something was incorrectly or unfairly done. Sir, and the question is, as a practical matter, when you request records from the VA particularly, but also from DoD, it's very common to get a response back that is something less than fully helpful. It costs too much. Here, we've given you an excerpted part of your records. We cannot find all the records. We're not going to copy those for you. You have to come in. And the way to get around those sort of practical difficulties, theoretically, is to make the request under the proper authority. So a veteran themselves making the request is able to waive all of the releases of information that would allow them to receive their own records. But for advocates, there's this layer of how, under what authority can I compel you to produce these records? And the answer is usually FOIA. And so the good example is to send a FOIA request paired with a release of information to the Department of Veterans Affairs, demanding that they send the entire record unredacted. There are variations on the language, but it usually says, and this is on that website that I talked about, which is why I don't want to get into it too much, but it's some version of all written information, including notes included on the left flap, right flap, center flap, appended to the outside of the folder, any email, corresponding around this request. The point is to, as exhaustively as possible, say, I want every damn thing that is associated with this person's name. And that has produced boxes like this, is what I usually get from the VA on a veteran's record. And it's often well outside of the the statutorily required FOIA response time of 30 or 20 days, whatever it is. So 9 months later, I usually get a box like that. But it is the only way with respect to the VA that I have found to make sure that I'm getting everything that they have. And again, the website has what those types of requests look like. I also don't want to conflate requesting something from the VA with all the other places you need to request things from. So there is NARA, or the National Archives, that often become, if somebody doesn't know whether they have the records or not, they say, well, you should ask NARA first. Do ask NARA, and that's what you use the SF-180 for, but be aware that NARA often needs to be engaged on the subject multiple times. And if you look at that NARA web page where you can do an automated records request, what you'll find is that there are actually sub-pages that don't have their own little links on there for particular types of medical records requests. So the services will often say, we no longer have those records. We have sent them to the National Archives, but your normal National Archives request on the SF-180 would not pull that information. You need to go to this sub-page that's there. Yes, and that is what is so terrible about this. That's what makes this so hard. And I don't pretend to be able to stand up here as an advocate who's done this a couple of times and give you the good answer. You have to, this is not a precision instrument, and that's what makes this so difficult. You must, on multiple occasions, engage the same headquarters or agency in order to get what you think is everything. I just had a discharge upgrade decision come back from a BCMR adversely, and they cited to evidence that was contained in none of the 4 records pulls that I sent to the National Archives. So, this is a real issue, and it's just something to be aware of. And on the one hand, the first SF-180 is just never going to be enough. And on the other hand, I want to just impress upon everyone the importance of looking outside of those National Archives. Often, medical records that were produced by the service headquarters says they don't have them. The VA says that they don't have them. The archives don't say that they don't have them, but we contact the individual hospital at Fort Drum and ask for records on a letter essentially written by me and the veteran, and we'll get those records back. Although if you look at the website, it says, please direct all inquiries for records to the National Archives after 10 years or after 5 years. We send all records that way. So it's just a place that's very difficult to operate in. I wish I could say that if you just did these things, you would exhaustively get the record, because that's what fairness would demand in this process. And I haven't figured that out yet. Medical records, just to say it, there are military medical records. There are civilian medical records created while somebody was in the military. There are Veterans Affairs military records post-service. There are civilian records created post-service. And then there's theoretically the possibility of civilian records that predated the military service at all. And you often need all of that in order to build the complete record, particularly where your argument is health-based or has a health nexus. Statements. So there was a question about, is it good enough to just start creating personal statements, and is there any standard on which they should be written or any form? Statements become often what we need. They become the only thing that can work because of the difficulty that the gentleman described in, a veteran will say, I know I got diagnosed with PTSD. I know that they prescribed me drugs. I know that I went to the doctor 3 or 4 times. I know I went to my troop medical clinic 3 or 4 times, and none of it comes out of the records requests. So what the strategy then is to say, okay, who were your roommates? Who was your commander? Who, do you think your mom or your dad would remember this? And to get a personal statement that doesn't, pretend to give diagnostic information, but can say, Kelly was a normal girl before she deployed to Germany. When she came back, she was different. She began to have financial difficulties. She began to have severe relationship trouble, and she told me that she was raped. That, again, is total hearsay, and sometimes the only thing that you can get, and given more weight than you would think if you're sort of accustomed to a normal sort of criminal evidentiary process. So I really want to emphasize these personal statements. The last thing, you'll notice that nowhere in the standards that the DRB or the BCMR operate under did I talk about post-service life, except to the extent that it's sort of implicated in clemency. Right, wrong, or indifferent, the anecdotal information in the sort of commonly held common sense on this is that if you can show that your veteran is doing okay since the separation, that helps your case. If they went to school, if they have a job, if they're contributing members of society, you can sort of pull on some of these biases that these panels or these either senior military officers or civilians may just have and use that to your advantage in your application. Or not treat those facts if they are to your disadvantage in your application. But just to say that a lot of these guides that I'm going to talk to at the end really emphasize this point, and I think it's a good one, which is to say, to the extent that you can say, look, it was exceptional. My guy or my gal did what they were supposed to do, had an issue, and they're battling back from it, that makes your application stronger. So the plan, and again, these are just some key considerations to talk about. So at the very beginning, I scintillated everyone with this total cliffhanger about one being binding on the other and the other one not being binding on the rest. So a discharge upgrade issued by the Department of Defense is binding on the VA, which is no surprise, but a VA character of service determination, which we'll talk about in a little bit more detail in a minute, is not binding on DoD. But it raises an issue as to sequence when you're advising somebody who's going to pursue both of these types of action. Is it persuasive to have a favorable VA character of service determination included as evidence in your discharge upgrade brief? Some people say yes, some people say no. I think it would depend on the type of action that you're bringing. I don't think it would hurt. And it may be that CSDs being faster can sometimes achieve a client goal intermediately while this longer discharge upgrade process sort of goes on. We also talked about exhaustion. So the boards for correction of military records require exhaustion, and the common sort of response is, yeah, you got to go to the DRB if you can before you go to the BCMR. But it is important to note that there are other sources of exhaustion. So one that came up for me is the Army Human Resources Command. So there was an issue that the DRB was not empowered to solve, but Human Resources Command could still solve. So I had to get an adverse decision from HRC before I could go forward to the BCMR. And it's just to keep your eye out for what other sources of relief there are that must first be exhausted and ideally would solve your problem for you, but must first be exhausted before you bring your case to the BCMR. And then knowing, particularly with BCMRs, the question is that they're more widely empowered or essentially totally empowered in most cases. What do I want to ask for? Discharge upgrade implies that I want to upgrade the thing that most people call a discharge, but you can ask for a ton, and we talked about that, because these BCMRs can do a lot. So I want my characterization of service to go from other than honorable to honorable. I want my reason for separation to go from personality disorder to at least something neutral, ideally something positive, successful completion of term of service. And I want my RE code, even though I don't plan to re-enlist because I'm 65, to go from RE4 to RE1, just because when I go to an employer who looks at my DD-214 who knows this stuff, I want them to see RE1. And so it's, as a matter of strategy, important to make sure that you are exhaustively asking for what you want because you don't want to have to send one of these things back because they take a long time. So the process in applying, and this is the actual hardest part of discharge upgrades practically, is what does one of these things actually look like? Because if you go to the website, there's a form, the DD-149 or DD, I think it's 993. And if you look at this form, it's usually auto-fillable. There is no giant blank to argue all these things that we've just talked about, including citations to a Hagel memo, medical records. It's just a form, and it's got like this little thing. It's like, on what basis do you believe your discharge should be upgraded? And a very common issue for veterans is that they fill the form out because they're used to filling forms out, and they send it off, and then they get denied because it was necessary, but it was clearly insufficient to the type of legal argument that they were making, which creates a lot of issues in terms of exhausting your ability to then help them in terms of later submitting a full brief. So again, another thing to look out for, don't tell someone that they should just go get a discharge upgrade, or they might consider a discharge upgrade, because sometimes they just send in the form and then they put themselves in a much weaker position going forward. Sir, really what is just an observation on the continuing difficulty of this process. There are other resources that, and I've sort of made a very tightly edited, selected list of resources that have at the back, and then if you really go through those, they'll connect you with a couple of others. But what you find with the resources as to the legal arguments, again, is that these are actually not complicated arguments to make. They're just really resource intensive, and which is why I've listed a couple things that you might consider including and beginning to request before you actually sit down to write the brief that corresponds to the see attached notes in that tiny form that you're actually going to submit as the thing that causes the action to proceed. So the question is, can you characterize what is the burden of proof that's required to rebut the presumption of regularity in government affairs?
Never.
The unsatisfying answer is that the statute contains no criminal law-esque statement of the burden of proof required to overcome the presumption. So you get a sort of potpourri of appellate decisions that comment upon what that statement or that burden of proof might be, but it's really an unsettled question. But you can sort of answer it backwards by seeing the types of things that they allow, to the extent that evidentiary standards and burdens of proof are at least theoretically, built into each other. So by allowing, my statement, Leo Flor, he was different and now he's worse, to carry any weight, you can see that this is not a clear and convincing type issue. But so I don't have the answer to the question. I don't know that there is an answer to the question in a satisfying way. The next question is, what do you do when you get the decision that you don't want? What are your options? And again, it corresponds to the place where you brought the action in the first place. But the basic headline and things to think about. Discharge Review Board, again, the place where we want to go first if we can, or have to go first if we can. There was a consideration back there that I didn't talk about, which is records review or personal hearing. If the Discharge Review Board decided on records review, your application, you are then entitled to request a personal hearing. If you requested a personal hearing in the first instance, received that hearing, and then got the adverse decision, out of luck. There's no sort of second swing of the apple or bite at the apple at the Discharge Review Board, other than the ability theoretically to go into federal court under the APA and say that they were just arbitrary in their decision. But is the APA, or is a federal court using the APA going to require you to exhaust, which there's not, again, clear case law on, but it seems like in most of the circuits they've said you have to exhaust, so go back to the BCMR and then come back up to us with an APA claim on a 6-year statute of limitations. So that's a DRB. So if you want the most bites at the apple and the most time to develop your record and an intermediate decision upon which to strategize for your second bite at the apple, a records review would be what you'd want to do. That also might take 4 years. So you've got to kind of figure that out, what's best for your client at that point, what your client thinks is best for themselves. The boards for correction of military records have the ability to issue a decision, and there's not this ability to compel a hearing at the BCMR. I just want to note that. You can ask for a hearing. They used to travel on a circuit and give hearings, but they don't have to issue it. So you can ask for it and they just say no. But in any event, when you get your first decision from the BCMR, you have 1 year to request reconsideration if you bring new and material evidence. Otherwise, that becomes game over. So you exhaust these things. And this is the problem with our veterans who just fill the form out and send it off, is that there's actually not a ton of review that's useful to us. The last sort of place to go is, okay, well, I guess I'll go to federal court. And there are 2 potential actions to take into federal court that I'm aware of. One, again, is the Administrative Procedure Act, saying that these decisions by one of the 2 boards or both boards were deficient in a way that meets that very high standard under which the APA operates. Or 2, in some cases, there's this thing called the Little Tucker Act, where if there's a $10,000 valuation and you are basically alleging that I was wrongly separated, breach of contract essentially, I want to go to federal court, usually the district court, and bring this Little Tucker Act action and say that they breached contract, there's a wrongful separation, and I'm entitled to money damages and perhaps a reinstatement in terms of injunctive relief. So the thing to highlight there, because the way I presented it might create this impression, that does not require having gone through these DRB or BCMR actions, and in fact, having done that might run you out of the statute of limitations for your Little Tucker Act action. Character of service determinations, this other thing, and I think useful thing, particularly, well, only, if the veteran's goal all along, in addition to a lot of the sort of pride-based and I think valuable reasons people seek discharge upgrades, often another goal in there is I want VA benefits that I believe I earned or that I need, particularly in the case of health benefits or perhaps non-service connected pension benefits. And a thing to note here, we said before we went into discharge upgrades that no sort of credentialing was required. Once you get into VA CSDs, you need to be an accredited attorney because you're really going to begin advising on the development of claims. And in fact, it's necessary to initiate the action. So I also want to bring everyone back to our color chart, which had red, yellow, green, and recall where this CSD lives in the realm of possibility. So we're talking about a veteran who's seeking federal VA benefits where the characterization of service is other than honorable, bad conduct discharge, which is the full name of the characterization of service, again, annoyingly, where the bad conduct discharge is issued by a special court-martial, not a general court-martial, and then the set of characterizations of service that are called uncharacterized. We didn't really talk about those in the beginning, but just to say it, there are many folks who normally within the first year of their service, it becomes clear that it's not going to work out. And rather than issuing an administrative separation or a punitive separation that will be punitive over the long term, there is this ability to just say, you know what, we're not going to characterize the service, we're just going to separate you. And the different services have different names for them, but I collect them under the group of uncharacterized. So those are also amenable to a character of service determination. So those are the three that we're talking about. Interestingly, in my client base, this issue comes up a lot because a large number of my clients fall into one of those three characterizations of service, which is an avenue to just talk about something tangentially briefly, which is the dishonorable characterization of service. People talk about it all the time. I think it's like 0.001% of all separations, and that's not like the token 0.001, I think that's the actual number, of all separations are dishonorable. It's rare that somebody would do something and that everybody would let it get to that point that that's the actual thing that happens. It happens, but those are rare. And they also can't use a VA character of service determination. We had this phrase, under the conditions other than dishonorable. If you were just reading it and you knew what the characterizations of service are, you would say, okay, well, all 5 characterizations of service, because they are not dishonorable, qualify under the standard, and you would be wrong. And it's actually what we just talked about in terms of those middle 3, if you were to sort of array them from best on top to worst on bottom, other than honorable, bad character discharge issued by a special court-martial and uncharacterized, that's what we're really looking at to see whether they were under conditions other than dishonorable, from which you can imply that honorable in general are per se under conditions other than dishonorable, and dishonorable is per se not eligible under this. There's too many negatives in there. The second question that comes up as a practical matter once you learn about this is how do I actually initiate one of these things? Because there's not a VA form for it, and there's a VA form for everything. So this is initiated by for a veteran who falls into one of these categories, applying for the benefits. And then the VA is going to respond, often not identifying it by what we're calling it here, but say, we'd like to learn more about your service before we determine whether you're eligible. So the tactic that we often employ is to essentially predict that this is going to happen and attempt to preempt it, which has worked in one case. So here's all the argument when you send this thing back. So just decide it in the first place, call them eligible, and we'll be good. So I think it's worth pursuing, but the way this is classically initiated is a veteran not knowing applies, gets the response back from the VA, and then has usually 60 days to respond and then inform the VA's determination. This is a good place to point out that almost everything the VA says or does is appealable. So even if you don't respond within 60 days, get a decision back, you theoretically could appeal it on a year timeline. So just to note that. And the question in these VA CSDs is, notwithstanding the characterization of service, although it is relevant, how would the totality of this veteran's service be characterized as whether it was under conditions other than dishonorable or not? So this is where my guy who had 6 years of great service, event, diagnosis, quick decline, separation, we want to look at that 90% of the service and mitigate that 10% through the diagnosis and say in the totality of circumstances, this person's service was not under conditions or not under dishonorable conditions, and they deserve VA eligibility. So the question is whether service in a combat zone for a period less than 90 days,
no less than 90 days,
which can be a factor in determining eligibility for some other VA benefits, is relevant in this and not no. Now, whether there was combat service is certainly relevant to the extent that that service was laudatory or created some issue or created an injury, but that there's not that, whether or not you satisfy that very specific criteria is not relevant to this determination. There are a number of benefits that require combat service for certain durations as elements of their eligibility, which could be an independent basis to render somebody ineligible, but it's not going to factor into this very specific type of determination as to whether they were separated under conditions that are other than dishonorable, if that makes sense. Well, and the comment is that, combat service is relevant, as are a number of other types of experience in the military sexual trauma being the one that really jumps out. So the duration, I think, is less important of 90 days or 180 days or 6 months. But the fact of the experience is exactly what this is about. To say that this guy got a dishonorable, an OTH, but look at what they did. They deployed 4 times. They got blown up 3 times. There are 2 Purple Hearts here. There's a PTSD diagnosis. I think we can say, given that record of service, there's some sort of legal crowbar to now say that we should not be considering him to have left the military under dishonorable conditions. And the last, I've underlined it and asterisked it again, the bars, the federal regulatory and statutory bars, take a look at them. I think there are 5 and 6. These are things that are just game over for you. So even if there's an honorable characterization of service, but desertion, it's a weird combination, but desertion is the reason for separation, or AWOL greater than 180 consecutive days where the insanity exception has not come into play. Like, these things will just shut down your ability to seek VA benefits regardless of your characterization of service. So it's often something to just make sure you check that one of these statutory or regulatory bars has not been ticked off, and that's where the general court-martial limitation for eligibility for VA benefits actually comes from. It's one of the statutory bars, I believe. So those are important. They seem not important. They come up with high frequency in the types of cases where these characterizations come up. Procedurally, at the end of the day, we've really just sat down with a veteran. They've identified that they had a characterization of service that's keeping them from achieving some goal. And the question is, do we want to do 1, 2, or 1 and 2? And the discharge or the character of service determination can often be a useful precursor in developing simultaneously the discharge upgrade application, because all the same evidence is going to be important for both, and the shape of the arguments actually is very similar in both. It was unfair, they did something wrong, so he should be or she should be considered to have separated under conditions other than dishonorable. So that's one thing to note, is that often we're researching with that terrible records request process for both of these types of actions simultaneously. Another thing to think about with the VA is it going to be better for me to respond, attorney at law? I'm going to try to explain that I don't charge my clients, but you're going to assume that I do. Or is it better for this person to respond in their own voice? I don't know the answer to that. I think it's very fact specific, but I've succeeded with both of those tactics where we essentially ghostwrite the response, at least in the first instance, from the veteran back to the VA to say, look, I take responsibility. Let me just tell you what's gone on with me. And the VA, hasn't required that there be a argument A sub 1, argument B sub 1, sub 2. Like, a very informal letter from a veteran with some evidence is often just as effective as the thing that I would have, signed my bar number to at the end of the day. Multiple periods of service. This is actually not within VA CSDs. It's a way to get around VA CSDs, but I just want to bring it up because it comes up. VA eligibility can be established on 1 period of service. And what anyone who has reenlisted somebody or been reenlisted sees is that periods of reenlistment are marked by a brief discharge and then the reenlistment. So I have a client right now who had 4 periods of consecutive service, so 3 reenlistments, and there's a service-connected disability that resulted from the first 2, both of which ended in honorables because he reenlisted, and then his last one was an OTH. So as to benefits for which eligibility results from the last one, we don't have to argue the issue if I can say the PTSD came from the first 2 and he was honorable. And it can also work with non-consecutive periods of service, which we see a lot of folks with, where they were in the Marines for 4 years, saw the error of their ways, got out, did something else, and then joined the Army for 6 years with a 4-year intervening period. So it's not always necessary to just see that last characterization of service and think that's the field that we are going to have this fight on. You know, if you can get back earlier and get more favorable terms, I think that's something that you want to do. And then the last one I mentioned before, which is just, do you want to attempt to preempt this thing and be a smarty pants and say, I know what you guys are going to say, and here's my counter argument, or do you want to let it develop? And there are reasons to let it develop, particularly if you continue to have trouble getting your records, but you want to save a date for a claim as the effective date for the payment, for example. Selected resources, repwavets.org, which is a site that we created. The Connecticut Veterans Legal Center, if you go to this website, they have 3 large publications that I find excellent. So I didn't produce them, I know Margaret Middleton, who's the directing attorney there, I recommend them. Swords to Plowshares has much simpler client-centric materials to take a look at. It's not going to really have as much detail as you might need to complete one of these things, but I think it's a good sort of overview. And then the Practicing Law Institute has a number of CLEs that you can essentially watch on demand that can really go into the depth of how to do these discharge upgrade applications specifically. So happy to take your questions. The one question that always comes, if you've seen one of these before, I do this at the end of all of them, but why don't you have an apostrophe in veterans? Like, we'll go through, we'll talk about all kinds of interesting stuff, and people will be like, why is there no apostrophe on veterans? So there's something called an attributive noun, and as long as you're not intending possession when you use veterans, it's like sports car or farmer's market. There does not need to be an apostrophe. The plural form acts as an adjective would. So that is what I got.